Well, I know some of you have to go, so it's the last session, so I'm not going to anticipate that we're going to get a whole lot more people. I hope we do, but just to be realistic and to keep everyone on schedule, I just want to get started. My name is Jeff Ifrah, and with the Ifrah Law Firm, we've started our own firm after having been with two mammoth-sized law firms over the past 20 years, and started out as a prosecutor, actually, federal prosecutor, and now for the past 17 years have been defending all sorts of organizations who are wrapped up in government agency investigations. Most recently, that's meant FTC investigations. The FTC has been bringing complaints, really record-sized complaints in terms of dollar volume and damages they've been requesting. Last week, they unsealed a complaint against one of my clients, Iworks, and they're requesting $279 million of damages, and that's down from $479 million. But obviously still enough to be really, eyebrow raising. In the past couple years, really this year and the past couple months, I should say, the FTC has brought some really super-sized complaints from a damages perspective, which really have caused the industry to take note of the fact that they're becoming and looking to continue to become a very aggressive agency. So there really aren't that many folks with us today, so I don't want to be too basic, but maybe we can just get a sense of who's here in terms of folks represented. Are there affiliates here? Okay. Any other type? Are there merchants? All right. And where do some of you folks who didn't raise your hand fall in, other than being shy? Networks. I was going to say networks. Okay. Yes. Payment processors. Okay. Well, listen, the truth is that the FTC authority sweeps broad, and in general, they're going to go after the people that are making the most money. That tends to be a theme that is true across all government investigations. If you are making a lot of money and the government knows where you are, they will come after you. Generally, it's that simple if they believe the conduct that you're engaged in causes harm, and that harm from the FTC perspective is defined as causing harm to the consumer. So we'll go through these slides, and at any moment, please interrupt me and ask questions. There's some neat function where you can send me questions electronically, apparently, but I'm hoping you'll just raise your hand and ask the question out loud. So like I said, I'm Jeff Ifrah with the Ifrah Law Firm, and you can meet some of our other colleagues and team members outside at our power booth right outside the conference entrance. The point of today's presentation, and by the way, if anyone wants a copy of today's presentation, feel free to come up and get a business card, and I will tell you how to access that through our internet site. We author two critically acclaimed blogs. One is called FTC Beat, BEAT.com, which covers everything that's going on in FTC investigations. And the other one's called CrimeInTheSuites.com, and that's a legal blog that covers white-collar stories exclusively. And we were recently honored with being ranked as the 13th top legal blog, the #1 blog in white-collar issues and legal analysis, and we hope you enjoy that blog. And up on that blog are a whole bunch of stories. We've just posted today 2 complaints that got unsealed by the FTC against Dannon. I don't know if you've seen these Dannon active commercials with Jamie Lee Curtis promising that if you eat the yogurt, you basically will look like her. So not surprisingly, Dannon, experienced a huge spike in sales, which again became a magnet for FTC enforcement, and they've settled claims. And the FTC actually is very interesting. I mean, they actually in their press release today said that Dannon couldn't substantiate any of the claims that Jamie Lee Curtis was making, not claims about the beneficial effects of yogurt or probiotics, and also not any health-related claims about longevity that were associated with eating the Dannon yogurt, which is really good because I'm allergic to milk and I was like losing out on the whole life-saving thing. So I'm really excited about the fact that Proactive apparently doesn't do anything. And I'm sorry, the active cultures in the probiotic yogurt don't do anything. As for Proactive, that's a whole other story. All right, so what are we going to talk about? So We're going to talk about an insider's understanding of the FTC, try to get you an understanding of what goes on, who they are, why they bring these cases, how they bring them, give you some real-life examples, and try to let you see what they mean to you based on the fact that your affiliates, networks, and vendors here will have examples that cover everybody that's here. Give you some advice on staying out of the government's crosshairs, and also some critical advice on, in the event the government knocks. We prepared a separate presentation called 5 Important Steps to Take If the Government Comes Knocking. This is on our website, ifrah.com/government. And if you go up there, you can download it in PowerPoint or PDF. And this will go through all the steps you should take from the moment the government knocks on your door to retaining a lawyer. And it's pretty simple, and we know everybody has a short attention span these days, especially folks that work on the internet. So we tried to reduce the actual content, used pictures, and it's in color. So what else could you ask for? All right. So who's the FTC? The FTC is the agency obviously responsible for enforcing anything having to do with consumer protection complaints. And who are they going to come after? Recently, we've seen them coming after affiliates, advertisers, merchants, not just the owner of the product, but also the advertiser of the product. They will go after anyone in the chain, according to David Vladeck, who heads their consumer protection. And what do they come after? They come after any claim. There's a whole bunch of statutes that the FTC enforces, but the ones you guys care about is Section 5 of the FTC, which enforces deceptive trade practices. Now, what's a deceptive trade practice? Something that misleads the consumer. Well, what misleads the consumer? Well, this is what the FTC does. There's no specificity really in the statute as to what those terms mean, and the FTC, unfortunately or not, is given full discretion to interpret what those terms mean. And when they bring a case, they're generally going to be deferred to. So it's not as simple as you would think. It's not a matter of looking at a claim and saying, oh, of course, I'll never lose 900 pounds in one day. That must be misleading. Well, what about 10 pounds in a week? Well, what about subscriptions? Well, what about negative option plans? Well, what about continuity billing? What about all of that type of stuff which is somewhere on the page? You know, is it too high, too low? All of those things are things that the FTC gets to interpret. And who do they come after sometimes is more important than essentially what the scope of their authority is, because that's really how they make up that decision. They can't go after everybody. And how they make up the decision as to who to go after is really something that you need to understand, because that's how you can keep them out of your hair. In terms of why, the why, we're going to talk about all these things, but in terms of the why, the main thing is to protect consumers. That's their main mission. And how they do this through a series of inquiries. There could be informal or formal investigations. You may receive a subpoena, something that they refer to as a CID, which is a civil investigative demand. This will be a request which will ask you a whole bunch of questions. And of course, you should never complete anything that a government agency sends you without consulting with an attorney first. What essentially happens, believe it or not, and I would say 90% of these investigations, is that you, the affiliate or the network or the vendor or the merchant, end up essentially making the case against yourself. Because when the FTC comes out against you, they've got very little information typically to build a case. But what they do have is the authority to make you respond to questions, and a lot of people are just a little too willing to do this. And so what happens is they ask you questions about the volume of sales, about specific advertisements. They ask you to collect up your advertisements. They ask you to talk about your revenue, and they wrap it all up and send it to them in the most unrealistic time frame imaginable. And people do it. Why people do it, I don't know. Men do it more than women, statistically. Men tend to be, I guess, more trusting, and they assume, although you'd think women are more trusting, when it comes to government investigations and responding to the FTC, it's always the men that come off looking stupid, because the women tend to ask for more information and tend to look around before they answer things. Men think that if they can just respond to this stuff, it'll go away. What do they have to hide? Okay? That's the worst approach, and that's what gets people into the most trouble. And when time after time, we have clients who complete the CIDs before contacting us, and then we're stuck with their responses, and when the complaint comes out, the client automatically knows where all the information came from. It came from the client. And it doesn't really come from some, I think a lot of us watch a lot of TV, NCIS and CSI, and we think they're these secret chambers that the government has where they compile all this secret stuff because they're monitoring everything we do. That's the most exaggerated sense of how the government works. You help the government work. The government has very little insight into what's going on other than the advertisements they can see on the internet or consumer complaints. Consumer complaints trigger the investigation, right? But in order to get the detail that the government needs to bring a case, they rely on subpoena power and on you filling out CIDs. Now, obviously, you have to fill them out honestly, but an attorney can help narrow the questions that are asked. An attorney can help advise you as to whether you should even answer the questions, what the consequences are for not answering the questions. And that's why it's critical that with any government inquiry, no matter how innocent it comes across, that you stay informed and do not reply to anything until someone advises you. Now, David Vladeck gave the advice to marketers in terms of the who. We're talking about who, so he said it. Who enforces this? The FTC. What statute are we talking about? We're talking about deceptive trade practices, okay? And who do they go after? Anyone in the chain between a seller and the ultimate consumer, okay? So that's pretty broad. Now, obviously, they're going to pick and choose, and they're going to take the low-hanging fruit. That's what the government does every time. The low-hanging fruit is generally those marketers or advertisers or merchant who they can go after because they have access to them, because they've made a significant amount of money, because the assets are in the United States. Those are all things that lead to how the FTC exercises its discretion. Now, we talked about the fact that the statute is very broad. I mean, they're basically coming after something that's unfair and deceptive. And every single client we ever have says, well, that wasn't unfair and deceptive. I disclosed it. But the issue that the FTC takes is where you disclosed it, how you disclosed it, whether it was sufficient disclosure. And the fact, look, every one of these cases, essentially, clients come back with, well, you know, why are we defending the stupidest consumer on earth? Like, why are we using the standard of stupid consumer? Okay, that's the standard the FTC uses. So obviously, it's very problematic, and we're going to see some advertisements at the end that I want to ask you some questions about and see whether or not, you know, you've learned anything at the conference and learned anything here. And I'm sure a lot of you already know a lot of this stuff. And obviously, look, the major tension that we have as lawyers trying to advise clients in this space is we all want you to stay profitable. You've just spent a whole 2 or 3 days learning how to become more profitable. And a lot of the stuff we're talking about cuts into that profitability. And the real way to manage this is to figure out how you can continue to stay profitable and grow your business without inviting the FTC in and without getting the government, and it's not just the federal government, because it could also be the state government, because the attorney generals through the various 50 states have miniature deceptive trade practice statutes, which they can also enforce. So there's a lot of people looking after this, and really the number one way is to really reduce, it's no magic. The magic is trying to figure out how to do this, but the consumers are the ones that get the state AGs and the FTC interested. And so reducing those consumer complaints and addressing the consumer complaints as they happen, I can't underscore enough how important that is, because the government will always kickstart its investigation based on how egregious and how repetitive the consumer complaints are. So things like Better Business Bureau complaints that come in envelopes and any other type of agency where consumer complaints are reported through you need to be addressed. Now, the FTC has issued new guidance, and last year this came in the form of endorsement guidelines, and these new guidance basically, this new guidance addresses the way in which you advertise a particular product. So the FTC has been coming out against fake news stories, bloggers, any type of way that you communicate the message. All of those forms of communicating the advertisement have also been considered to be misleading and deceptive. So if you're on the Wall Street Journal, and while you're linking on to the Wall Street Journal, you get a pop-up ad that says that there's a lady in your area whose teeth just got a lot whiter, okay, and you plug into that story, that lady doesn't live wherever you happen to be when you're opening that story, right? We all know that, okay, but does the consumer know that? No, the consumer doesn't know that. And does that product really work? While it may not work or may not be as effective as the ad maintains, is that deceptive and misleading? Well, it is if the product doesn't work. It is if that woman doesn't really live in that town. It is if the entire news story is made up. All right? It's placed in a section on the Wall Street Journal or any newspaper on the internet, and it's placed there intentionally to help the consumer believe that it's news. It's news being reported by the Wall Street Journal or by any newspaper. That this is how you push that product out to the market. This is how you get all those eyeballs. That's the prominent place you want to put those advertisements. Well, the FTC and its new guidelines is cracking down on fake news stories and fake news blogs. And the recent case of FTC versus King Car is one example where the FTC is now coming after affiliates who try to drive traffic to these fake news stories. This is something we saw with the SEC. I mean, fake news stories and fake blogs are not exactly something that's new to the enforcement world, all right? It's new to the FTC because they are now expanding their authority from saying it covers deceptive advertising, which covers fake news stories. It sounds pretty logical, of course, but nevertheless, it is one of the most popular ways that you push a product out. So when Vladeck says he's coming after everyone in the chain, that means advertisers, brokers, and affiliates. Okay, the case against Iworks that's been in the paper recently, the Iworks company itself was advertising products which it did not necessarily own, but it also covered products which it did own. But it doesn't really matter. At the end of the day, they're going to be held responsible, according to the complaint anyway, for the products for which it was advertising. Now, what about the fact that they used a broker to run the ads? All right, this is a defense of every single advertiser and every single merchant. I signed up for the ads, I got to see the ad, but then what happened? It changed, okay? That's what every single merchant and affiliate says, and broker says. It changed. I didn't know. All right, I didn't know because there's this network of evil affiliates out there, right, who just want to make money because they make money as soon as, right, there doesn't have to be actual, they make money as soon as the sale it goes through, sometimes as soon as the click is made, regardless of whether or not there's a return or a refund, right, or a chargeback. So if that's the case, then they're incentivized to make the ad the best possible, and, you know, the poor advertiser, the poor merchant, had no knowledge because this all went on so quickly and he or she didn't have the ability to really react fast enough. And then, you know, all of a sudden, you know, there were multi-million-dollars worth of sales that went on before they could change the ad, or they never changed the ad. Right? Those types of defenses are not really going to work unless you can really show that you had day-to-day management over your broker and day-to-day management from a compliance perspective over those ads, that you had people dedicated to searching those ads on any basis, and that the ad never changed. And there are a whole bunch of different compliant ways that you can ensure that an ad that you set to put out to the market is actually the ad that ran, and that the consumer purchasing the product is actually purchasing the product from the ad that you intended to put out and not someone else's. But those are not defenses that the FTC has never heard before. But nevertheless, the burden on all of you here is going to become greater every single day to ensure that those types of things aren't happening on your watch, and if they are happening, you better have a good reason why you didn't notice. Now, disclaimers, in terms of the world of disclaimers, obviously, almost every single complaint that the FTC issues, it's not like any of these advertisers or merchants didn't have disclaimers on their products. All right? I mean, all of the products that are sold have some form of disclaimer. The question, of course, is whether or not it's prominent enough. The question is whether or not it's clear enough. The question is whether or not it's above the button, and even disclaimers that are above the button may not be enough. Look, at the end of the day, the FTC has made recent cases and has successfully obtained judgments for millions of dollars worth of money, notwithstanding the fact that there was a disclaimer, that it was placed above the button, that it was in proper size font, and all of those things. This really pisses off a lot of clients because at the end of the day, they come in and say, you know what, how much more could I have done? But you need to be aware of it. You need to be aware of it, and you need to manage this along with all the risks that you manage in your business. And you need to figure out whether or not you feel that the consumer is truly on notice of what they're being billed for, especially if there's some sort of recurring fee, some sort of upsell attached to the product. All of those things that are contained in the disclaimer are typically held not to be sufficient disclosures. All right, so if you're selling one product, but they're getting another product, even if they're getting that other product for free for a certain amount of time, and even if they have the ability to cancel that product in the future, okay, that's been held and been pursued by the FTC as being a deceptive trade practice. So paid bloggers, we sort of covered this, but just to get back to it again. Any type of payment that's going out to bloggers or fake news stories in order to get your message out, any of that has been, all of that type of conduct in this recent case of FTC versus King Car has been held to be a deceptive trade practice, misleading consumers through false advertisements. So although traditionally a false advertisement although this would not traditionally fall under false advertisement, it is now, and you need to be aware of it. Fake reviews. Again, this is all stuff that you as whether you're a vendor, merchant, or an affiliate, or a network, or a broker, need to be aware of. Okay, what types of reviews are available out for your products? The FTC went after went after this particular defendant in terms of a case where a fake iTunes review was posted, and you're going to be looking for any type of news review. You're going to look like, just like the FTC would require if you were in the healthcare space to substantiate a health-related claim, the FTC is going to require you to substantiate any type of review that's made on a product that's being advertised. So if you're pushing through an advertisement or a review or an advertisement that contains a link to a review, okay, that advertisement, even if all the disclaimers and everything else is in place, to the extent that it links to a false review or a phony blog report, that's going to be considered deceptive. So what do? One of the most powerful things that the FTC has in terms of power is something called a temporary restraining order. Does anyone know what that is? What is it? Yeah, so what happens there is before you're even able to present a defense, all your assets are frozen. All right, now this obviously creates incredible leverage for the FTC to settle anything. So when you hear about these cases where the complaint is filed and a settlement is issued all on the same day, that's because of this power. And it's a ridiculous power, but a lot of powers that the government have are ridiculous, okay? It doesn't really take much. Okay, because any judge is going to rubber stamp anything that the FTC gives it to rubber stamp. Most of these judges are here in Las Vegas, and they've never not rubber stamped one of these TROs. The only issue is whether or not internally the FTC can get the authority to obtain a TRO. The way the FTC works is it's divided into regional offices, but the main department of the FTC is in Washington. What will happen is once there's a bulk of consumer complaints, the attorneys general for a particular state or attorneys general can come together through a committee that they have, the National Association of Attorney Generals, and they can pursue a case if they see consumer complaints being collected and falling into a similar pattern. They can refer those to the FTC. If you go up on the FTC website, you'll see that the FTC actually often coordinates and announces its cases with the states. And what's going on there is that the states have collected these consumer complaints and coordinated with the FTC, who's the agency expert when it comes from a consumer protection perspective, and they will say, yes, we've seen these from multiple states. They'll initiate an investigation. When they initiate an investigation, you don't always know about it right away, even though it might involve your product or your advertisement, because first they assign a staff attorney to it. The staff attorney's responsibility is for collecting information on the advertisements. What those staff attorneys will do sometimes is they'll have agents from the FTC go undercover to make buys so that they can substantiate in a complaint that they were misled by a particular product's claim and that they purchased that claim, and here's how it worked. The complaint will then walk through how that purchase experience went and how that person was deceived, make references to the consumer complaints. The staff attorney's job is to then get approval internally from the FTC, and in order to do that, he or she will have to advocate on behalf of their position, which is usually to obtain a TRO and to file a complaint and obtain injunctive relief. That recommendation goes through a whole bureaucracy, just like everything else in the government. So sometimes it takes a long time. But at the end of the day, commissioners at the FTC, 7 of them, will vote on whether or not a particular complaint should be filed in court. So just because a staff attorney has been assigned to a case and just because a staff attorney has reached out to a particular client doesn't necessarily mean the case is going forward, because you have multiple opportunities throughout the process to settle with the FTC prior to that complaint being filed. But I'll tell you, every staff attorney is motivated to do what every other prosecutor in the country is motivated to do, which is make a name for himself or herself. So they're not really in a big rush to settle anything. And if they're going to settle it, it's going to be on terms that you never would ever want to live with, like you can never do business in the industry again. All right, those are the reasons why you get lawyers involved and why you hope that they can advocate on your behalf for a better outcome. Now, what happens in that process is if they get the sign-off from the commissioners, they can file a temporary restraining order with the complaint immediately. And what that does is freezes all of your bank accounts. And what that essentially does is put you out of business, put you into a position where you feel forced to have to negotiate in order to continue doing business. Now, how do they identify what bank account you're at? That's where these undercover buys come in. One of the interesting things that we've seen, by the way, is where an agent goes and does an undercover buy on an ad, and the whole complaint that issues will actually be the result of that agent's experience. So an ad may have actually gone out there for 1 day or 2 days and then been changed when your compliance department found out about it because it was misleading in some way. Nevertheless, they will go and issue a TRO for all sales that have been generated across all ads across multiple years, despite the fact that only one ad or one buy or two buys may have actually resulted from the ad that the agent saw and then made a purchase from. Those types of defenses are regularly made, and they're not necessarily always successful. If you're at the stage where this type of activity is going on, then obviously it's going to be very complicated. You're going to need, obviously, a good set of attorneys, and in addition to that, it's going to be very costly. But what a TRO essentially does is it automatically puts you in a very tough position because your money's been frozen, your assets have been frozen, you can't continue to do business, your merchant accounts have all been shut down. This can all happen without your knowledge. They will get subpoenas to your banks. They will identify your banks through these undercover buys, and when they do that, the banks will cooperate and are prohibited by statute from telling you about the investigation. So that, when you read about an FTC complaint against any of these guys in the paper, that's the process that's happened. Now, sometimes there are indications that something's going on where you think an investigation might be occurring, and the best thing, obviously, to do is to try to coordinate quickly. Some people reach out to the FTC ahead of time, ask if they're under investigation. Not a course that I recommend, but people have done that because they get a feeling that something's going on or because a banker has leaked information to them that they received a request from the FTC for records. Now, the TROs are not always approved internally. I'm a little cynical about them always being approved by judges once they're presented to them because I think judges always just agree. I mean, in this country, you know, you think that the judiciary is separate from the executive, but it's not. It's really one branch, because we only have two branches of government, right? We have the legislature, and then we have this judiciary executive, and they all work together to basically screw everybody. So you have to know that, okay? You're not going to get a fair day in court, and if the government gets in front of the judge with a TRO request, regardless of how outrageous it is, the judge is going to approve it, okay? Even federal judges who don't run for re-election and actually could exercise independence don't. So you need to be very careful with these advertising claims, and you need to think about this stuff ahead of time. And if you have a compliance program, you have to remember your compliance program is only good if it works. And if by the time you're in this situation, it's going to be very, very tough to convince the FTC that your compliance program worked. Most of the cases that end up settling at this stage of the game end up settling with injunctive relief, which I mentioned before. What is that? Injunctive relief is where the FTC basically tells you you're going to agree to a bar. You're no longer going to act in this industry for a period of time, 3 years, 6 years, okay? And they're going to kick you out of the industry, and you're not going to be able to participate at any level. And you're going to have to agree to that bar. And then they're going to suspend a certain amount of the payment, okay? Because these people who are being charged in these complaints for $200, $300, $400 million, they're obviously not paying $200, $300, $400 million. And that money has long ago disappeared. So the FTC is never going to get it, and they know that. What they are going to get are disbarments of individuals and try to prevent these bad actors from participating in advertising roles again. Typically, most clients don't like that because this is the only world that they know. So they'll fight on that. And sometimes you'll have a little bit of success fighting that. But most of the time, these settlements end up with a small amount of money being obtained through the TRO process. And, you know, because most of you are smart enough that you don't just leave all of this money sitting in one or two bank accounts at any one amount of time if you're lucky enough to have that much, right? So most of them end up settling with these injunctive relief provisions. And again, all of that is negotiated directly with the FTC staff attorney, but usually after a TRO or a complaint's been filed before a relevant district court judge. Now, what judge do they normally file it before? It doesn't necessarily have to be the judge in your backyard. It really could be any judge in any district, because if you're working over the internet, your consumers are literally anywhere in the country, right? And as a result of that, they have a right to have jurisdiction, as it's called, to file anywhere they want. Now, they tend to file in jurisdictions they like, where they get favorable results. So a lot of these cases end up getting filed in Las Vegas, even though the companies are not in Nevada. But the recent most significant and aggressive actions have been filed here. Now, how are you going to stay off the FTC's radar? Well, like I said, what they're doing from an affiliate perspective, one of the things that you want to do is make sure that your advertisement has gone through some sort of compliance review, whether or not it's internally or whether or not it's with some sort of outside lawyer. And again, you want to make sure that the advertisement that's actually been approved is actually the one that's running. So you have to have some sort of system in place to try to monitor whether or not the advertisement that you've put out onto the internet or approved, or that your compliance department approved, is the one that ran. There are multiple ways, I'm sure you all know, that you can track back where a consumer, what ad a consumer saw that led to the purchase site, and you need to think about those types of things when you're thinking about advertisements that can land you in trouble. In terms of disclaimers, obviously upsells are very vulnerable for attack, okay, despite disclosures. Personally, I think the whole thing's kind of silly, but at the end of the day, that's what the statute does. It protects stupid consumers. So it's not really a defense that the consumers that are purchasing are very stupid. In a recent complaint, the FTC alleged that the reason why consumers were duped in a particular case was because although there was a disclaimer that disclosed that there was going to be monthly recurring charges, the merchant and the advertiser knew that very few consumers actually check their credit card statements. So that's a fraud. Okay? What do you think of that? Yeah, it's just stupid. Okay? But these are the types of arguments you hear. These are the types of things that are signed off by judges all the time. All right, so at the end of the day, a lot of times the FTC determines how successful or deceptive a particular ad was by really looking at to me, what I feel is that instinctively, the FTC is really making a determination, although they'll never tell you this, on the quality of your product. If they think that you're selling a product that no one in their right mind would truly buy if they truly understood what it was, they're going to be more likely to come after you. And they're going to be more likely to find that your claims and your advertisements are misleading. Why? Because they're starting off with an assumption, even though this is not part of the legal analysis and you'll never hear them say it. But in internal discussions that we've had and cases we've defended with Vladik and others, we always hear, and tell me about the product. Can I see it? Can I see the CD? Can I see how many people truly made that amount of money? Can I see the checks that were going back? Can I see the grants that were issued? Can I see evidence of the fact that people were losing weight? Can I see evidence of the fact that you were getting positive letters? Did anyone tell you they were really happy with your product? Okay, that's not really evidence of deception, truly, right? I mean, you could argue it certainly isn't evidence of deception, the fact that you don't have a lot of letters from people thanking you for your product. But that's the position that the FTC takes in almost every one of these cases, okay? Because they're questioning how you could have hundreds of millions of dollars worth of sales for a product that they question really works. And so, what are the types of things that they're most likely to attack? What types of programs have you seen in the news or on websites that are particularly vulnerable to FTC or AG investigations? What types of? Money fast. Yeah, make money fast. What do you think is sorry? Teeth whitening. Teeth whitening. Well, that's not fair. I said that one. Debt settlement. What? Debt settlement. They just announced today a huge settlement against a debt relief merchant. What else? But the product. What product? Diet pills? And sweepstakes, grants. They haven't gone out against the manhood advertisements as much as you'd think. But there's a common theme to some of the things you're throwing out there. Work from home, make money, debt relief. What types of people are going to be looking for that type of promise? Poor people. Poor. Sorry? you're going to have to start sharing what's so funny if you're going to keep laughing. It's not fair because these guys aren't laughing at all.
I said the FTC hasn't filed many complaints against penis extension pills because no one wants to review the evidence.
There you go. See? Now everyone's laughing. Maybe it's because, they're not going to be able to ask the question, but why would you buy this? Why would you want this? Why didn't you review the evidence closer? I was desperate. Nobody's complaining about those products? They're a little embarrassed. Actually, we're going to get to that issue in a minute because that's actually one of the reasons why some of the most egregious claims don't get prosecuted. But sticking to this issue of poor people, the FTC recently has really made it an issue and an enforcement priority to go after what they call kind of the last frontier. These are the people who are down on their money, right? Who are either in foreclosure or have already lost their homes, they've lost their jobs, and these people are considered particularly vulnerable because of the economy. And as a result, the status of the economy has really changed a lot of enforcement priorities across a lot of agencies. But when it comes to the FTC, the way that it's changed the enforcement priority is that they will look at these folks who are particularly vulnerable, who are really spending the last dollars they have on, pipe dreams. Okay, and so what they're going to look at, they're not really going to care about your claims for proper disclaimers. They're not going to care about the fact that you could substantiate some of the blog reviews for your product. They're not going to care about the amount of money you spent on the product or on advertising or on compliance. When it comes to those particular products, you're going to have the biggest problems defending those cases. So you should know that ahead of time because you're going to want to be a little more careful if those are the products that you're advertising or selling. You're going to want to be a little more careful about your disclaimers, about your advertisements, and also, again, about responding to consumer complaints. All right, customer hold times for those products are scrutinized, responding to written complaints, especially repetitive complaints, your return and refund policies, all of those are going to be more scrutinized when you're selling a product that they consider to be worthless. All right, but again, no one's going to be able to show you a part of a statute that says a worthless product is unfair or deceptive, right? I mean, there are tons of products you can go into any retail store and buy that have questionable value. But there's no statute or form of relief that's going to give you relief because that was unfair or deceptive. You went into a store and bought it. But when it happens to a certain group of people that are considered to be particularly vulnerable, okay, this is a reminder of the telemarketing era, right, when the FTC did this all the time, and other agencies as well. Now, there are some other products that were mentioned. And one of the, and I want to keep that in mind too in terms of these other products, but before we do, one of the things I was going to say is just a reminder that this copy, this brochure, we had a whole bunch of them on our Power Station, but I don't know if you have one or not, but if you want, this is just specifically addressing the issue of what happens if they come and knock on your door. Like I said, it's just, I'm just saying in my experience, unfortunately, I don't know why, but men are more likely to talk to government agents and respond to questions than women, and just because there's so many more men in here than women. Let me tell you, if the government comes and knocks on your door, you don't have to talk to them. You don't have to give them papers. You don't have to give them stuff that you don't have copies of. You don't have to do all of the stupid things that we see every single day, okay? You have no obligation. They're going to put pressure on you, and they're going to tell you it's going to be much easier for you if you just comply, okay? That's complete BS. People who get in the biggest trouble are the ones who are the most helpful from the beginning. So please just, if you don't remember anything else, just please remember that first point, okay? Everyone should be courteous in responding to a government inquiry, whether it comes in by phone or by mail, but courteous doesn't mean you have to be stupid. So you can be courteous and at the same time, unless there's a properly issued subpoena asking for materials, ask them to come back another time, or that you'll get in touch with them, or that your attorney will get in touch with them. Secondly, if you provide any materials pursuant to a subpoena they bring or a CID that they ask, make copies of them. Time and time again, clients come to their attorneys, don't have copies of what they gave the FTC or the state AGs or any Consumer Protection Bureau at any level that's communicating with you. Sounds like a kind of simple thing, but again, whatever reason we do it, we assume things are going to get better and that they're going to go away. We want them to go away. So in our rush to kind of hope that that will happen, give away the only evidence or the only copies of stuff that we have, all right? If you're a larger organization, you should try to appoint one person to deal with these inquiries. That way, and everyone should know that if anything ever comes up, go to that person, okay? That's a better way of maintaining a uniform message and also ensuring that people don't give out incorrect advice. At the end of the day, you don't want to be giving out incorrect advice. Sometimes, I don't want to say a lot of times, but sometimes the FTC builds cases on incorrect information that was provided to them the first time they knocked on the door. All right? So these are all things to remember, and again, we have copies of this 5 steps you can take to kind of mitigate negative outcome here. So let me just, let's go through one of the ads that was a recent exhibit in an FTC case. Is anyone involved with marketing or advertising any acai berry product? All right, well, this is kind of old news, I guess. It's not really that old, but I guess everyone's already heard about this. This is an actual exhibit that the plaintiff used. And I just want to have you all take a look at it. Let me just see if I can scroll. Whoops. Oh, my God, my private stuff's on here. Let me just, I don't know, the ad's actually a little bigger. But that's okay. What? Well, actually, he doesn't have technically 5 fingers, so I guess his middle finger, that's true. It's his longest one. All right, so take a look at this ad, and can you take a guess at what the FTC found particularly deceptive about this? Now, keep in mind, okay, again, this product's going to come under scrutiny because the FTC doesn't believe it's a valuable product. It's taking advantage of a group of people who want to lose weight, all right? And just right away, it's going to become vulnerable and suspect just because of that, all right? Again, that's not in the statute, but that is typically a way that they make their decisions. So if you are high risk, if you're involved in a high-risk product like this, or anything else that is likely to be purchased by someone who's a little more vulnerable to some form of marketing than someone else, of course, every marketing and successful marketing, of course, is that way. But if you're involved in a product like this, you got to be really careful with your claims because the FTC is automatically going to raise an eyebrow. All right, so take a look at this. What do you see that is deceptive and misleading in this ad?
Number 1, weight loss supplements in 2008.
Okay, good. That was not substantiated in that case. What else? Right. If you have any type of advertisement that's making a scientific type claim, the substantiation requirements that the FTC has are so impossible to meet, it's not even worth trying. Okay? We've seen clients who have shown up with advertisements from physicians from African countries I've never heard of. Those are obviously not going to work. What else? So what happened with Oprah and Rachel Ray? There must have been some connection to acai because every single acai advertiser says Oprah and Rachel Ray approved the product. So, right. So the original founder of acai was on Oprah, and spoke about acai, essentially the actual fruit, not this product, by the way, but spoke about acai berry as having these effective. One of the things you want to. The lesson from this, by the way, another lesson is you don't want to piss off Oprah. Okay? She has so much power in this country, especially from a marketing perspective, that throwing her name on something that she wasn't paid for is really stupid. And if you can afford to pay her, that's a whole nother story. I definitely want to give you my card then. But, you don't want to put out there in the market someone as powerful as Oprah or Rachel Ray for that matter, but certainly Oprah. She took note of this. She essentially initiated the investigation into almost the top 3 marketers of this particular product, as well as the merchant for this product. So that, like you said, the product, the acai berry as a fruit was on Oprah, and she did indicate that she thought it had some form of improvements to metabolism. It took off from there, but the advertisement that she endorsed this product, okay, was false. Now, that's what it says, right? How would you defend that that's not what it says?
Testimonial from Oprah.
Yeah, well, that's true. Well, how about the language right there? Is there any way to defend the language that was used in that ad?
Well, if she approved it, she approved it.
The way it's worded makes it seem like a testimonial that Oprah approves this product.
This product, Right. So the fact that they would come back and say, well, she did approve the use of acai berry, you don't think that works, huh? That was essentially part of the defense. Of course, this was a pretty quick settlement. But these types of advertisements could be found everywhere. Everyone was running these ads. The amount of blogs, I mean, look at how successful these ads were in promoting acai. It became the #1 beverage for a while. Of course, Palm is Palm put it in all its pomegranate drinks. And so Palm acai, Snapple came out with an acai berry drink. This was all off of the heels of the successful marketing push for this product, right? So it was a very successful marketing campaign, and there's nothing wrong with putting it in all those products, right? But what is wrong is promoting that it has any health-related improvement that can be made by using the product. All right, now you can't really see what I'm going to read to you because this goes to the penis enhancement issue. What about if someone is embarrassed to complain? So what happens in those circumstances? If someone's actually embarrassed to fill out a consumer complaint and write to the Better Business Bureau that their penis actually didn't grow, right? Or their video of Girls Gone Wild wasn't actually what they were expecting, right? Those aren't the types of things that you'd think people would complain about. And as a result, there's no consumer complaints. And as a result, the FTC or the state AGs may not really be getting notice of it and may not actually invest resources in it. I think that's actually what's happening with the penis enlargement and the products. I think that people are a little embarrassed to complain. I think that's why we haven't really seen too much in that area. So it might be a little bit of a lower risk area from that perspective. But what happened here? So in the fine print, which you can't really see very well on the screen, it says it's a monthly preview program, 30-day money-back guaranteed, cancel anytime, right? And then in the fine print, it basically says that once you receive your first video, if you haven't canceled within the free cancel period, then you'll get one more every month at that price. Plus, there was an upsell. But putting the upsell product aside, this case actually got recommended for criminal prosecution. And does anyone know, how did the FTC become aware of this particular problem, and why were there so many consumer complaints about this product?
Parents of the girls?
No. Who knows where the parents of these girls are, but they weren't complaining.
The success of the guy behind it, Joe Francis.
That's why? Because he certainly was successful, right? High profile, that's true. But what the consumers were complaining, though. What did the consumers complain about? What? They weren't wild enough? Yeah, it was deceptive. The FTC probably wouldn't get involved in that, although that would be fun to watch, but they probably wouldn't take up the claim that they weren't really that wild. What? No, it's the consumers. Focus on the consumers. What is a consumer going to complain about with this video? It has to do with the fact that they didn't read the fine print about another video coming. Why would a guy who's ordering this first one not want to pay for... Thank you. Jeez. Anyone who's got a... Because his wife found out about it. It's very easy to know that in 7 to 9 days you come home early from work every day and watch your mailbox, okay? But no one told me that I had to be back there the second month and the third month and the fourth month. That's how it happened, okay? This is a case. That's right. Who orders, Netflix doesn't, people don't even order movies in the mail anymore. But, so you're not even thinking about that mentality. But that's the type of circumstance that's going to get you into trouble when you have that type of language in a disclaimer that can't really be used. And it led to so many consumer complaints by these men who were all yelled at by their wives for ordering these videos, right? That it ended up that they all complained about being deceived because they didn't see the language in the disclaimer, even though it was there. All right, so the disclaimers in those circumstances aren't going to necessarily help. And like I said, that led to a whole host of other problems. All right, just the time that I wanted to leave at the end of the presentation for any questions that anyone has about a particular product or a particular aspect of the government agency or anything else. Yes, in the back.
Can you envision a scenario where a blogger who's just putting out content and just using Google AdSense would be brought into a prosecution for something to do with one of those advertisements? And if not, just in general, could you see a scenario where a blogger
Well, first of all, presently there are four class actions that are pending involving the use of the word Google or Google AdWords or Google Analytics or Google anything. So aside from having to worry about the FTC in that scenario, you also have to worry about Google. All of these campaigns work from home using Google, have Google drive your success, obviously discs that use the word Google in the product, okay, from a blogger or an affiliate I know you're not talking about that, but I just wanted to say as an aside, you always got to worry about that because that tends to find its way into the advertisement or the blog review of the product. So you got to be careful about that. But as an aside, you know, I think that certainly the FTC would say that that's problematic, but whether, depending on what, again, just go back to our basics on what the product is that's being pushed out there and how much revenue the particular blogger made off of the report, I think that the bloggers, I think that for a whole host of reasons, it's unlikely that the FTC would pursue the blogger per se. But that doesn't mean that they wouldn't pursue the owner of the product or the primary advertiser or the broker. I think they use knowledge of, your knowledge of the fact that that fake blog review was used, even though they say anyone in the chain. I mean, government resources aren't going to be spent to go against everyone in the chain, right? So there are going to be determinations made, and normally those determinations are made based on how much money they recover. And they're not going to really recover a lot from a blogger.
Has Google been brought into any actions as any part of the chain, to your knowledge?
No. I mean, Google has a case against 4 brokers right now in Salt Lake that's been going on for a while. There's another one in Illinois, and there's a smaller one in LA that they brought. The gist of it is that the use of the word Google violated trademark laws. What remains to be seen that's kind of interesting, that we're kind of interested in because one of our clients is sort of involved, is whether a settlement with Google will have any impact on the FTC's related allegations that the use of the word Google was unfair and deceptive to the consumer who thought that Google was behind a particular product. It's not clear, but I assume they won't care. Google's actually been settling those. They have these, contingency fee lawyers that just go around the country suing anyone who uses the term, and they settle them relatively inexpensively. So I can't imagine that the FTC is going to truly care about the fact that you settled with Google. But, it could be a strategy used. Did you have a question?
How do you think the FTC does it go through, I call my bank and say, you know what, there's been recurring charges or contact my police department?
Well, it's tough to complain directly to the FTC. Most people go through their state attorney general. Every state attorney general has multiple offices throughout the state typically, and they actually have a consumer complaint day where, unfortunately, one of the assistant AGs will sit outside and do intake on all these consumer complaints. The other way is that they will complain through the Better Business Bureau. There is a way to complain to the FTC directly online, but I'm not really sure about how many people actually complain to the FTC online directly. So if you went to a police station, you'd be directed typically to the Attorney General's office or to the Better Business Bureau. And those are pretty effective, actually. I always thought the Better Business Bureau was kind of a dead agency when it came to the development of the internet, but it's pretty effective in triggering these cases. The other thing you mentioned is in terms of chargebacks. I know there's at least say something to the payment processors that are in the audience. I mean, one of the things that the FTC did in this Iworks case, which is a little unusual and new, is they basically wanted to use evidence of the chargebacks and multiple merchant accounts as evidence of deceptive trade practice. To me, that's not really a deceptive trade practice. That's really some form of, alleged fraud against the bank. And this is a new terrain for the FTC. They've never actually brought a complaint before where they've claimed that merely opening up multiple accounts or having multiple merchant IDs or having a high chargeback rate itself. The high chargeback rate itself, actually, in the Komodo case, they did use statistics to show that if you're above, I don't know, what was it, Jeff, like 1 or 2%, being above 1 or 2% was a red flag, which initiated an investigation. Now, the banks and MasterCard Visa Association, obviously those can all be helpful in triggering complaints and investigations too. So if the merchant's getting those types of, if the processor is seeing or the merchant's seeing those types of chargeback rates, at least according to that judge in Nevada, that's enough per se to make a fraud finding. You know, I don't know that anyone's actually studied that. What I can tell you is that in the cases that we've seen, the number of complaints is usually in the hundreds, and the chargeback rates are normally 20 to 30%. We've seen them as high as 65%.
What I found interesting is that you said a good faith defense doesn't always work. If an affiliate, a marketing company has 1,000 affiliates, and randomly every month he looks at the ads of 6 or 7 of them, make a random check to see if they're using the correct formatting and verbiage, etc.
Right.
And then he's held liable, even though he made a good faith attempt to check on the veracity of the verbiage being used by his affiliates. I
Right.
thought common sense would suggest that he did make a good faith attempt to ensure that what was being put out was actually his product as advertised.
Right. So the question is about good faith attempts to actually monitor advertisements when you have multiple advertisements, 6 or 7, multiple affiliates being run at any time, and how many ads can you really monitor? And how about the fact that when you actually monitor an advertisement and find it and fix it, why can't all that be used in your favor? Well, of course, as defense attorneys, that's the first thing we would raise. The reason why it doesn't totally work all the time is because the FTC generally takes the position, if they hate your product, if they think it's worthless, and if you've made a lot of money, they usually take the position that you were on notice of the fact that this was being done, and you did very little to truly stop it. And of course, you know, how many efforts can you really show that you took as a result of finding that one ad or fixing that ad? I mean, that's all going to be up to your particular operation. But in the circumstances where you're high risk, where you're promoting or advertising a product that the FTC is going to find particularly vulnerable because it doesn't like it, or because it's vulnerable because poor people are buying it, you better make sure that those advertisements are compliant and that you're pushing out the advertisements that you actually approved and not allowing a significant number of sales. The other thing you could do, of course, is you could show the FTC that you can allocate sales to advertisements, right? So if you have evidence of what ad ran when, you can show, well, I didn't really make that much money off of it, and you can use that to leverage a lower settlement. I mean, instead of settling, if they bring in a complaint for $500 million, and you can show that the 1 or 2 ads that actually are somewhat a little more egregious, you know, actually only generated sales of, you know, 5,000 until I pulled them, then, you know, you've got the beginnings of a settlement strategy. Yes?
How seriously do you think the FTC views consumer complaints on blogs, like rip-off reports, that sort of thing, the source of which may be disgruntled ex-employees or even competitors?
These are typically their number one, what we call kind of whistleblowers or witnesses. Okay, those types of disgruntled employees, especially call center managers, they're the worst. Those are the first people in the door, first people they'll go after. It's the first people, I mean, the staff attorneys will look for those types of people because they have the most knowledge. They can get up, they can tell a sympathetic story. And, you know, those are the types of people, just like in any other government investigation, you need to be worried about. When those people are fired or terminated, from an employment perspective, you should try to ensure that they're not allowed to discuss, you know, confidential information, that if they're contacted by a government agency or receive a subpoena, that they need to discuss with you before disclosing that information. Those are all terms you can try to require. At least that way you can try to prevent, you can raise a defense later if they disclose the information without your approval. You can try to post comments in response to those ripoff reports. You can try to address it. But let me tell you, every single client, and for this I can say 100%, every single client that comes in our door always has a really nasty story to tell about the former call manager, the call center manager, the former affiliate, the former broker, the author of the ripoff report, whatever the case is. The FTC always uses those materials front and center in their complaints. They're always quoted, okay? They're always quoted, and they're always acted on as if they're 100% reliable. And the fact that so-and-so was having an affair or stole or did any of those things is all completely irrelevant. It's fun and entertaining, but it's irrelevant, unfortunately.
Even when they're anonymous, completely anonymous consumers, for instance, do they actually make efforts to find out who they are, or do they just print up the postings?
No, I've never had an experience where the FTC has posted an anonymous posting without knowing who the person is. So, I mean, there are circumstances where they black out their names in the complaints, but they're making character assessments just like we would as to how that particular person would stand up and hold up and whether they're valid, going to make a good witness, et cetera. And they're using, and based on that, they're running that particular blog post in their complaint or using it as leverage. It's really amazing because in a lot of ways, no matter how much we've progressed kind of technology-wise, litigation strategies from the government are kind of antiquated in that way. Well, we haven't really seen any cases involving the FTC and payment processors. I'm not really sure why per se, other than the fact that the statute, they do have they do interpret their statute pretty broadly. But deceptive trade practices, I don't really think, we have a lot of payment processor clients. I haven't really seen any payment processor clients dragged in to anything other than some sort of witness role or document request. I think that's really because the source of the statute, as broad as it's being interpreted by the FTC, is really narrow in that regard. Now, like I said, this most recent complaint against Iworks, which is on the FTC website, and it's a client of mine, so I can't really talk about it too much, but that's the first complaint that we've seen where they've alleged like a quasi-bank fraud type allegation against the payment processor. I think that payment processors are more vulnerable to local, state, and federal prosecutors. And that's for a whole host of other things. Typically bank fraud. You want to make sure that your applications, the way that payment processors get in trouble isn't from the FTC, it's from the U.S. Attorney's Office, and it's typically because in your bank application materials, you deny being involved in a certain industry that you're in. Those applications, as you probably know, are multiple pages. They have all these boxes. They talk about every single issue because the banks don't want to see chargebacks. And if you say no to any of those when you actually do a little bit, or someone snuck something in through your pipeline when you weren't paying attention, or you thought it wouldn't make such a big difference, or you had really good low return rates, so you were willing to take a risk on something a little riskier, that's the stuff that gets you in trouble. Does that make sense? Yeah. No, that's exactly what they focus in on. They typically don't have that information until they're somewhat well into their investigation, because that involves banks returning subpoenas to provide them that information. But
So they're not actively, they don't have access through banks.
No.
Through real-time information.
No. The way they get that, like I said, it's just, this isn't really CSI. The way they get it is by an undercover agent going on, making a buy, and then when the buy comes through, they can access either the merchant ID or they can figure out what the merchant or issuing bank was, and then they backtrack through there with a subpoena to get the financial information. And from there, they can then start determining what the chargeback rates look like.
You've been pretty good at giving us a lot of information to stay out of trouble. I appreciate that. I'm wondering if you can generalize at all on how much success you have in defense against the FTC, or do they get their way, or 90% of their way most of the time?
Well,
And second,
yeah.
I realize it's an unfair question, but because it's so much case specific, but can you generalize at all on what these kind of defenses cost?
Well, it's all relative to how much they're seeking in damages and what they're seeking in terms of, injunctive relief. I think that cases that start out with a TRO tend to be less costly from a defense perspective because you're already screwed. They've got whatever assets you have left. You can't go in and say, I have an inability to pay, which is what every defendant likes doing, right? You can't really make that argument when they know they've got 5, 10, 15 million. So then it just becomes a question of settling with them. I will say that to the extent that we've settled cases on your first question, when our clients have been generally happy that they haven't been debarred, and we've worked, when we get in early enough, and when we get in early enough that we can actually help control the CID responses, we've obviously been much, much more successful. When we get in or take over for another attorney that has kind of screwed up, then people are really coming to us because we're in DC, we have relationships with the agency, and they're hoping we can improve upon a bad situation. So it's kind of hard to answer your first question from that perspective, but how much it costs? These cases it depends if you want to fully litigate against them. No one litigates against the FTC, which is one of the problems. But if you were going to fully litigate from the beginning all the way through trial, that could cost you probably $500,000.
I came here with the hope of learning if there were any circumstances of which I should be aware. And then from your comments, it would appear that many of the cases which come before the FTC are common sense cases, generally speaking, common sense cases, that the parties involved should be cognizant of in their own right, regardless of the FTC.
Well, certainly the FTC would agree with that, but, you know, a lot of times, I don't know that it's always that simple. You know, a lot of times the people aren't thinking about the value of the product that's being advertised. They're not thinking to scrutinize the newspaper stories. They're thinking about their role as being only part of the puzzle. The FTC uses the term mosaic, which is, you know, it's really the entire mosaic that's presented. And everyone kind of sees their role as kind of being small and inconsequential. So, I mean, they don't necessarily see the full picture the way I presented it to you to be able to walk away and say, wow, this all makes sense. Of course, I'm part of this whole chain that's being used to, you know, to deceive a consumer. I mean, there are a lot of people in that chain that might not have knowledge of the number of complaints, of the number of chargebacks, right? I mean, I've presented it to you in a way that you can see it from the FTC's perspective, but not everyone in the chain necessarily has that, the full scope of that. I'm going to be available up here for questions or out at our booth until 5, and thank you so much for attending.